I have a question of the opposition with regards to the remarks in the second reading speech. He covered amendment number 2, MAR 1, and noted that that addressed a similar provision with regards to commencement of the Act that under the Greens version would have come into operation under the 15th of March 2020 should that Greens amendment be successful. The reason I have raised that issue, both previously and in this particular amendment, is because we have a government that is unwilling to enact this legislation potentially. We've also seen governments of the other colour, where private members' bills have passed and eventually become acts, make the whole clock tick down the year or so that it takes for that bill to be enacted without provisions, which I, as a private member's, as a member who has moved much private members' business, know that we need to ensure is enacted regardless of a recalcitrant government. So my question to the Labor opposition is, how would your amendment with regards to commencement ensure that should the Marshall government not wish to enact this legislation, we're not waiting over a year for it to come into operation?
I thank the honourable member for her contribution and indicate we are utterly and entirely convinced by her persuasive arguments in favour of it, and I can indicate when we get to it the opposition will not be moving Amendment 2 MAR 1 and instead be supporting the First Amendment of the Honourable Tammy Franks. The honourable member is right. This government has an appalling track record of not. No. This government has an appalling track record of not giving effect to the will of Parliament. Labor hire licensing.
Are there any further contributions at Clause 1? Put it that Clause 1 stand as printed. Those for the question say aye. Against say no. The ayes have it. New Clause 1A. First Amendment is in the name of the Honourable T.A. Franks to insert new Clause 1A. The Honourable Ms Franks.
Thank you, Chair. I move amendment number 1, Franks 1. This inserts a commencement that the Act will be taken to have come into operation on the 15th of March 2020. As I think we know, it was on Australia Day, or January 26th this year, that I think we had the first known case of COVID-19 in this country. But certainly we saw state and territory governments then implement various phases of emergency management provisions, including declaring public health emergencies and so on. And in South Australia, the first of those declarations and recognition and cases was in train on the 15th of March. So that is why I chose that date. We could go back to the January 26th date if members wanted to go back to the first known case of coronavirus in this country. But it seemed to me not only recognition that this is a new disease that wasn't known prior to the commencement of that date, but it would also act, of course, as a disincentive for a recalcitrant government to stall the implementation of this legislation, because it will always eventually go back to the 15th of March.
Are there any questions? Honourable Treasurer.
Mr President, the government opposes the amendment, opposes the bill, and I guess this presupposes the legislation will pass in another place.
Honourable Mr. I've indicated. Okay. I'll put the question that the amendment in the name of the Honourable T.A. Franks be agreed to. Those for the question say aye. Aye. Against say no. The ayes have it. Are there any contributions on Clause 2? There being none, I'll put the question that Clause 2 stand as printed. Those for the question say aye. Against say no. The ayes have it. Clause 3, there's one amendment in the name of the Honourable K.J. Marr. The Honourable Mr Marr.
Clause 3. I move the amendment standing my name. This was a typographical error that has been picked up that refers to the wrong section, so I move that it refers to section 9 bracket 2, bracket B, rather than section 9, bracket 1, bracket B.
Are there any further contributions? I put it that the question is that the amendment be agreed to. Those for the question say aye. Against say no. The ayes have it. The question that clause 3 as amended be agreed to. Those for the question say aye. Against say no. The ayes have it. There are a number of amendments at clause 4. First is in the name of the Honourable KJ Marr. Honourable Mr Marr. That's the one you're going to withdraw. Okay. The next amendment is the name of the Honourable Mr Marr. Amendment number 3, Marr 1.
Amendment in my name, and again, this is a typographical amendment.
No further contributions. Put the question that the amendment be agreed to. Those for the question say aye. Against say no. The ayes have it.
That's it for clause 3.
Clause 3?
Sorry, clause... Oh, no, sorry. Clause 4.
Okay. Clause 4, there are a number of amendments. The first is in the name of the Honourable Mr Marr. No, sorry. Clause 4, amendment number 1, Benares 1. We'll deal with that next.
Thank you, Chair. I move the amendment standing my name. I'll speak to both amendments together. They are related. As I've already highlighted, they deal with the insertion of disability accommodation into the definition of a prescribed workplace. A disability is defined in Amendment 1 Benares 1 to have the same meaning as in the Disability Act 2018, and the Amendment number 2 Benares 1 provides that a facility not being a private residence at which residential accommodation, respite care or other supports and services are provided to people with disability will be included as a prescribed workplace. I'm sure if we looked at this legislation long enough, there are other areas that we could potentially pick up. That has been dealt with by the inclusion of a provision in the bill which enables us to expand the scope by regulation. But I do think it is important, for obvious reasons, that the issue of disability accommodation be inserted at the outset as one of those prescribed workplaces.
Any further contributions on this amendment? I'll put the amendment in the name of the Honourable Ms Benares be agreed to. Those for the question say aye. Against say no. The ayes have it. The next amendment's in the name of Ms Franks, Honourable Ms Franks. Amendment number 2, Franks 1.
Thank you, Chair. 1. This at clause 4, page 3, after line 36, inserts in the definitions of prescribed occupation B.A. work in the healthcare sector, or B.B. work in the hospitality industry, or B.C. work in the retail industry, or B.D. work in the freight transport industry. As I noted in the previous discussions in this place on this matter, that essential workers, of course, we have known and taken to be those who work in healthcare and our police forces and emergency services. And I know that note that in the Labor Opposition's bill, they've prescribed occupations as meaning work as a police officer, or emergency services work, or passenger transport work, or air passenger service work, and we've just included disability work and certainly that as a prescribed workplace, potentially, if the indication of the chamber is, to my reading, understood. So if you're in the police force, or if you're an ambulance officer or emergency services, or if you're in passenger transport work or air passenger service work, and now disability, you're covered. But if you work in the healthcare sector, hospitality, the retail industry or the freight transport industry, you need to rely on the prescribed, not occupation, but prescribed workplace. And I note that a prescribed workplace with regards to health is a hospital or private day procedure centre under the meaning of the Health Care Act, or a residential aged care facility, or a pharmacy, under the Health Practitioner Regulation National Law SA Act 2010, or a childcare centre or kindergarten under the Children's Services Act, or a school within the meaning of Education and Early Childhood Services Registration and Standards Act 2011, or a supermarket, grocer, delicatessen or convenience store, or a petrol station, including any parts of a petrol station that consist of a shop or shops selling goods by retail, or any other workplace, to be left to the whims of a recalcitrant government to determine. So that blue tape will not be cut. That presumptive COVID care will remain in the way of those who work in the healthcare sector more broadly and don't work in those particular prescribed workplaces. And I've noted, for example, the COVID clinics that we've got around the state are not necessarily all in hospitals or private day procedure centres. It concerns me that GP, for example, treating patients, or in particular somebody taking the swabs for COVID, for coronavirus, is not protected specifically from the blue tape for that COVID care presumptive treatment under this particular opposition model. Further, you might work in the hospitality industry. Well, unless I'm certainly reading this, unless that shop, perhaps, in the service station, in the petrol station, or perhaps there's a coffee shop in a supermarket, that would have you covered. But if you're just a retail industry worker, you're not covered with that presumptive removal of the blue tape for this workers' compensation treatment. In terms of the freight transport industry, we know more than ever freight transport has become incredibly important and an essential service. Those who have stepped up for us to keep us fed, who are now, with the restrictions and the roadmap to recovery being eased, are at the front line. The people serving us our food, the people pouring that frothy in the front bar of the Alma for the Premier, deserve the respect of the removal of the blue tape preventing this COVID care being afforded to them because of their occupations. I note that the opposition has said that they hadn't considered the situation of the GP. I find that quite concerning, that they hadn't considered the very people who are actually taking the swabs, analysing. Is SA pathology covered? If it's not necessarily in a location defined here under the Healthcare Act as one of the prescribed workplaces, I find it highly disturbing that we would move forward with the bill to afford the removal of the blue tape and a presumptive treatment instead of what are their workers' compensation rights already to frontline healthcare workers just because they don't operate out of a hospital. I find that extraordinary in this day and age when we're setting up drive-by services, and we are taking all of course, providing them with PPE, but we know that that is not in any way a complete protection, and we are putting them in danger to keep us safe and to keep us home. So while I heard the opposition's words that we'll sort this out between the houses, I remind the opposition of the numbers in this House being in support of the removal of this blue tape, but there is no guarantee in the other place from a recalcitrant government who has indicated through the Leader of the Government in this place that they do not support this COVID care being afforded to South Australians, as it now is in New South Wales, with the support of the Berejiklian government of a Greens amendment to legislation there, supported by the Labor opposition there, supported by One Nation and the farmers and the shooters and all and sundry indeed. Cross-party support and consensus to remove the blue tape of making it harder for sick workers to get the care that they deserve when they're out there caring for us. I note that unless some miracle occurs and a member of the government crosses the floor in the other place, the end of the debate on this matter of ensuring doctors and nurses and frontline health professionals and those taking the swabs and those analysing for the results of those swabs is not guaranteed under the opposition bill. And it won't be if the government continues to the form it has shown so far. So with that, I do urge the opposition to reconsider their position, to acknowledge that they've erred in the restrictions and the prescription of the workplace rather than the occupation on this matter, and to support the Greens amendment.
Are there any further contributions or questions with regards to the amendment? Honourable Treasurer.
Well, we join the Labor Party in opposing the particular amendment, Mr President. We oppose the bill, we oppose the amendment.
Ms Benares.
The amendments has been well made. Like disability, I think it's important that these are front and centre in terms of the legislation, and we will be supporting the Honourable Tammy Franks amendment.
I put the question that the Honourable Franks amendment be agreed to. Those for the question say aye. Against say no. No. I think the noes have it. The division being called for. Ring the bells. Time having expired for attending the division, the question is that the amendment in the name of the Honourable Tammy Franks be agreed to. Those for the ayes will stand in their place. The noes will remain seated. Call the Honourable Tammy Franks to be the teller for the ayes and the Honourable Leader of the Opposition teller for the noes, given it's your bill. There being 4 ayes and 16 noes, the amendment is lost.